very good afternoon, ladies and gentlemen. It is a pleasure to be able to address such an esteemed audience on the M&A disputes landscape in India. Just to introduce the speakers for today, my name is Sameer Shah and I am a corporate M&A partner with Khaitan and Company. As a part of my practice, I cater to transactional work across sectors and geographies and at times see them through to their logical conclusion and even beyond. In those scenarios is where we work with our partners and colleagues from our disputes practice and we battle test the contracts that we have written. I'm here with Sanjeev Kapoor, who is a senior disputes partner with Khaitan and Company, with several years of experience on advising on a wide variety of disputes. He also brings to the table substantial expertise on advising on transactional matters that have turned sour. One of the most celebrated ones that he has worked on, and of course we'll discuss that in a little bit more detail in our presentation, is the Docomo dispute. Even as we speak, he is working on quite a few live disputes that make the front pages of business dailies from time to time. This includes joint venture disputes, private equity disputes with promoters and vice versa, or for that matter, promoters warring with each other. To introduce the subject of discussion, through the course of this webinar, we will address certain common issues arising out of M&A deals in India, more so in the context of prevailing legal and regulatory landscape. And we will also provide certain suggestions how to preempt future disputes and address some of those challenges as you go through the process of drafting a contract. We do have a presentation that we will run through. However, at the same time, ladies and gentlemen, we look forward to receiving your questions. You will see in the webinar portal, there is a facility for you to submit your questions. Please, we encourage you to submit as many questions as you can, and we will take them towards the end of the presentation. To begin with, it is an undisputed fact that investor confidence and the certainty in the legal and regulatory framework of a country is quite a symbiotic relationship. Effective contractual enforcement has always been critical for boosting investor confidence. And those of you who have been reading business dailies in India do know that India currently is at the 63rd position on the World Bank Ease of Doing Business ranking, which is a marked improvement over previous years, and which also demonstrates the comparatively favorable investment climate that currently exists in India. Therefore, efficient dispute resolution mechanisms constitute a key component for promoting investor confidence. So what are the primary avenues of resolving commercial disputes in India? These include arbitration. You could arbitrate through certain established institutions, or you could indulge in what is termed as ad hoc arbitration, which is agreed contractually between the parties. You have the option of pursuing what are called commercial suits before commercial courts that are established under the Commercial Courts Act. Lastly, and this is probably more relevant for joint ventures and the life of an investment, where you could potentially pursue appropriate petitions before the National Company Law Tribunal or appropriate appellate authorities there too. Other forms of dispute resolution, such as mediation, are less prevalent in the Indian market, although efforts are being made both from a legislative as well as a governmental push perspective to try and encourage more and more forms of alternate dispute resolution to be used. The preferred mode of dispute resolution, as you can imagine, would vary greatly depending on the nature of the anticipated dispute. For instance, if there's a pure play shareholders agreement, it would contain an arbitration provision so as to keep the dispute private and confidential. Whereas if there's a joint venture where certain shareholders believe that their interests are being oppressed or mismanaged, they would undoubtedly wish to pursue the matter before the National Company Law Tribunal. Increasingly, as a matter of practice, we see investors prefer arbitration as a mode of dispute resolution, and Once I hand the presentation over to Sanjeev, he will talk about how Indian courts are taking a hands-off approach to arbitral process and how the arbitral process itself is greatly advanced at this given point of time as a preferred mode of dispute resolution compared, say, to a few years back. So what are the common factors that give rise to M&A disputes? And what are the categories of common disputes we see emanating from M&A transactions? So these could be claims for breach of contract, whether in the context of an ongoing shareholders agreement or a joint venture agreement. There could be shareholders disputes. I've spoken about oppression and mismanagement briefly. There could potentially be regulatory violations. And more often than not, these disputes tend to follow whatever is the resolution process provided under those sectoral rules and regulations. If there's any misrepresentation or corporate fraud, case in point, there have been celebrated scandals that have been spoken of in the past where there's been incorrect financial reporting that has been alleged either of the promoters of a company or of any other shareholders. Other stakeholders such as a statutory auditor have also been called into question. Or for that matter, there's a simple case of misconduct by company officers, whether out of a breach of fiduciary duties or directors acting in conflict of interest or acting in excess of authority granted to them. The breach of contract scenario is where we see a fair amount of dispute action, and that is potentially something which can even be addressed at a pre-contractual stage, and which is where we recommend that effective and thorough due diligence needs to be done prior to indulging oneself in a transaction. And there have been instances in the past where the lack of appropriate due diligence has indeed led to a very sour investment experience. There also needs to be clarity in contractual provisions around what is the extent of reliance placed on representations and warranties. Even beyond representations and warranties, there may be recourse for things such as fraud, but it's important that the language is exceptionally clear. Including effective dispute resolution provisions in the contract cannot be understated, because unless things such as governing law, seat of arbitration, the process for arbitration are very clearly spelled out, this may lead to ambiguity at the time when disputes actually have to be imposed. What you have in front of you is a slide that provides an indicative list of elements to bear in mind at the contractual negotiation and drafting stage. With this, I will hand over to Sanjeev to take you through some of the other slides that we have put together. Again, ladies and gentlemen, if there are questions, please feel free to feed them into the webinar portal, and we will take them towards the end of the presentation.
Thank you, Samir. And it's a pleasure to be on this webinar and share my thoughts with the esteemed audience. I would say when we look at it from disputes perspective, there are two things which are very, very important and very critical. I think obviously one is what is your legislative policy, what is your law, and the second is that how that law is being interpreted by the courts. Are courts interpreting that law in a manner which might seem to be too interventionist, or they are just interpreting the law in a very plain and simple manner as it is sought out to be by the legislature. First, I'd like to cover the legislative and policy reforms which has happened in past few years by the legislature with an intent to give efficiency and also to an extent certainty to the entire process. Last year, we had amendments to Specific Relief Act. We have amendments in 2015 and again in 2019 to Arbitration and Conciliation Act. Commercial courts have been brought in 2015, again amended in 2018, and we have got Insolvency and Bankruptcy Court, which has also come in. We will see the implication of these amendments and new legislations which are having on merger and amalgamation disputes and disputes of that kind of a nature. So we have seen that government had started working on it for quite some time, and we have already seen that in 1999 we had FEMA in place of FERA, which replaced the Foreign Exchange Management Act 1999 to facilitate greater foreign exchange flows, which had few critical changes. And one of the most critical change was that unless explicitly restricted by the regulation under FEMA, using foreign exchange for current account transaction and capital account transaction was permissible without special permission from the Reserve Bank of India. The criminal element which was there in FERA was also taken away as far as FEMA is concerned. And we have also seen FEMA, we have seen also changes in Companies Act. Companies Act 1956 was replaced by Companies Act 2013. And two critical changes which are very, very crucial as far as I think disputes of this nature were concerned was allowing shareholders to enter into agreements or contracts to restrict the free transferability of shares. So erstwhile Section 111A of 1956 Act, which led to quite a lot of disputes and defenses in cases of breaches, etc., of not performing parts of the obligation under shareholder were taken care of by these amendments. Also, the 2013 Companies Act permitted enforceability of optionality clauses in shareholders and investment agreements as a matter of contract law in India. Now, first of all, dealing with Specific Relief Amendment Act of 2018. Specific Relief Act is 1963, so it is of quite some vintage. We have not really seen any kind of amendments to that, major amendments to that act, except for the amendments which came in 2018. The overall intent of the Parliament behind those intentions seems to be to first make it very efficacious and efficient, and that is the reason as to why they have included timelines in that. And the second thing is the endeavor is that specific performance should occur as a matter of right. The discretion which was vested in the facts and circumstances of a case with the court, either to grant or not grant specific relief, has been either curtailed and in some circumstances even taken away from the court. And the endeavor is that in case there is a contract of which you can seek in specific enforcement, therefore then the specific enforcement of the same should happen as a matter of course rather than just the discretion of a judge. One more critical thing which has been added in Specific Relief Amendment Act of 2018 is with regard to infrastructure projects. Amendments have been specifically made at boosting investor confidence in infrastructure projects in the country. Special provisions for infrastructure projects have been created under Section 20A of the Specific Relief Act, which essentially prohibits injunctions being granted with respect to such projects which would cause any impediment or delay in the project. The amendment of the Act expressly prohibits the court from granting injunctions in suits involving infrastructure projects, and there has been a schedule which has been added in the Specific Relief Act which specifies the categories of such infrastructure projects. So quite a lot of infrastructure projects which got stalled because of suits for specific performance, etc., getting filed, the government had tried to remedy. There is also a provision for setting up of or to deal with suits for specific performance relating to infrastructure projects. So there is, and this is critical because I think anybody who practices in India will know that construction disputes form a substantial chunk of litigation in India, especially against state entities and PSUs. Other amendments which are very critical are to the Arbitration and Conciliation Act in 2019. Everybody is mostly aware of that 2015 there were 6 significant amendments in the Arbitration and Conciliation Act, Pre-2015 arbitration scenario needed a lot to be desired. The process was slow. Enforcement of an award in India was uncertain because of the courts adopting a very interventionist kind of an approach. This impacted, obviously, the merger and amalgamation disputes in India. Uh, these were tried to be rectified and to a large extent were rectified by 2015 amendments, which brought in certainty, efficiency, and speed in the process. However, it was realized that despite 2015 amendment, the arbitration in India mostly remained ad hoc arbitration, and institutional arbitration needed a certain kind of a push. And therefore, essentially to give a push to institutional arbitration further, amendments were brought in 2019. The 2019 arbitration amendments are aimed at bringing India at par with international best practices. And in certain standards, maybe we have been overzealous and over anxious in this. We have included something which is called an eighth schedule in Arbitration and Conciliation Act, which prescribes the criteria, qualification, and experience required by the individuals to be appointed as an arbitrator. There have been a broad-based criticism of such criteria on account of the inherent India-centric bias, resulting in quite a lot of widespread dissent of the effectiveness in encouraging international commercial arbitrations to be seated in India. We may only add that while the execution may have been slightly misdirected and the message might not have been correct, the intent of the legislature cannot be doubted, and that is clearly to streamline the process concerning the arbitration in India, to minimize chances of court interpretation and bring about a very quick, efficient, and cost-effective closure of dispute by reducing the scope of challenging and moving arbitrations from an ad hoc system to a more institutionalized system. Also, first time by way of 2019 amendment, the Parliament has proposed a constitution of something which is called Arbitration Council of India, which will promote and encourage institutional arbitration in India. ACI is empowered to exercise supervisory role and frame guidelines for maintenance of uniform professional standards in matter relating to arbitration. This will include the power to grade arbitration institutions on specified criteria, including available infrastructure, quality of arbitrator, compliance with time limits, etc. And also, towards this push towards institutional arbitration and to limit the powers of the court in this space, there is a section 11(3)(a) which has been introduced, which confers the Supreme Court and High Courts actually the power to designate graded arbitral institutions as appointing authority for appointment of arbitrators instead of the courts themselves appointing those arbitrators. One thing which is to be noted is that it is a very, very recent amendment, and all the provisions of this act has not been notified. There are certain provisions which have been notified. There are certain provisions which are in the process of being notified. How this is going to go down, obviously, will need some time. It's a new law. It's going to get tested in court. But the legislature intent is very, very clear. And the legislature intent is that it wants to bring about a push towards the institutional arbitration process. Interestingly, also, we have seen that there have been a specific focus with regard to commercial disputes. There have been Commercial Courts Act 2015, which has come up. Commercial Courts Act is specifically mandated that commercial disputes are adjudicated by specialized courts, being commercial courts and commercial appellate courts. This obviously will improve the efficiency and reduce delays in disposal of commercial matter. There are very innovative measures which have been included, which are not yet being practiced, but when they start getting practiced, I think that will make the process quite efficacious. To quote one example, Commercial Courts Act includes provisions for case management, which are not yet being utilized by the courts or the judges or the litigants, but once they start getting utilized, and in that particular case, the disputes resolution will become much more efficient by using those kind of tools. Other thing which the amendment to the Commercial Court Act does is that it brings in mediation. Everybody knows that mediation is something in India which is quite uh, underused and underutilized. Commercial Courts Act will require that in cases where you are not really seeking any kind of an urgent interim relief, you go in and seek mediation, go through the process of mediation. So that is also a positive kind of a change, because in many cases where people just go through and rush through the process without thinking, having a mediation process might be quite useful. Uh, Now, how is the enforcement of contractual obligations happening in India, and what happens when obviously these provisions of the law which has been put by the legislature actually reach the court and get tested out by the court? We have seen in past and essentially before 2030, and specifically in the contractual enforcement space, and more so in arbitration space, we have seen that courts had exercised too much of an interventionist approach, and it kind of would analyze an award which has been passed virtually on all aspects, whereby obviously the process becomes quite slow, and the certainty was lost, because every time you will go to the court, and court will give a very creative kind of an interpretation to an existing provision of law, and the certainty was getting lost because of this interventionist approach which was there by the courts. But because after 2013 it started, where courts started adopting an approach which was not very interventionist, and then it was cemented by 2015 Act, which is now supplemented by 2019. And now essentially it is very difficult and to have an award set aside as far as an Indian court is concerned. Obviously, India is a large country, and it needs some consistency, and maybe courts in some corners of the country wherein commercial disputes are not that ripe, and therefore judges are not aware to those kind of disputes, the process might be slow. But at least commercially sensitive centers of India, like Delhi, Mumbai, Bangalore, Chennai, I think judges are quite sensitized to the commercial nature of these disputes. And if you look at the judgments which are coming from those high courts, you will see that courts are actually adopting an approach which is very non-interventionist, and the approach is to actually support the awards and the process rather than to create impediments in that. With that aspect in mind, it might be useful for us to go through some of the cases where in very creative defenses were put in by the defendants, but courts upheld the enforcement of these kind of disputes. So first disputes which is making headlines, and obviously you will read it in tomorrow's papers, it is again making headlines because Supreme Court has delivered a judgment today in this very case, in a contempt petition which has been filed against the brothers of erstwhile promoters of Ranbaxy. And in this particular case, which is famously known as Daiichi Sankyo versus Malvinder Mohan Singh and others case, the dispute actually centered around misrepresentation and breach of warranties while entering into a share purchase and subscription agreement, which was entered into Daiichi Sankyo. Because of allegations of those misrepresentations, there was an arbitration which was filed against, arbitration claim which was raised against them, and Daiichi emerged victorious. And there was an enforcement proceeding of this arbitration award, which was brought out in Delhi court. And there were quite a lot of technical grounds on consequential damages and consequential losses which were raised by uh, the erstwhile promoters of Ranbaxy. But in its judgment, the Delhi High Court, among various issues, interpreted the scope of the arbitration clause that prevented the arbitral tribunal from awarding punitive, exemplary, multiple, or consequential damages. The respondents had contended that the tribunal could not have awarded consequential losses. Uh, However, dismissing this argument, the court held that consequential damages could indeed have been awarded by the arbitral tribunal, considering the meaning of the consequential damages was held to be interpreted, keeping in mind the terms surrounding it, like punitive and exemplary. This case actually highlights the importance of a very well drafted exclusion of liability clause, especially for representations and warranties. It also clarified the nature of damages that may be awarded for breach of representations and warranties. Many of the disputes which we have seen in Indian space are around representations and the warranties and how the valuation of the companies is done on the basis of those representations and warranties. And therefore, this is a very, very landmark judgment as far as that space is concerned. The another case which was also quite important was a case which was called Entity Docomo versus Tata Sons. It pertained to interpretation of FEMA regulations with regard to assured return and fair market clauses. And there were defenses which were taken that this is a contractual clause under which there was a minimal amount which was required to be paid, which turned out to be more than the actual value of the shares on that particular day, and therefore it was resisted before a London Arbitral Tribunal headed by London Court of International Arbitration, that it is violative of Indian foreign exchange management and regulation laws. However, the arbitral tribunal did hold that there was an obligation which has been taken by Tata in that particular case, and they have failed to meet that obligation. And therefore, it was not really a case of any FEMA or foreign exchange violation, but it was a case, plain and simple case of a breach. And for that breach, Docomo needs to be compensated. The awarded amount was in the tune of about 1.17 billion US dollars. It came to India, and in India, when the enforcement proceedings were going on before Delhi High Court, Reserve Bank of India actually intervened. And Reserve Bank of India intervened saying that the award is against the public policy of India and void as it opposed FEMA provisions. Delhi High Court actually rejected that contention, which was raised by Reserve Bank of India, and enforced the award on the grounds of violation of public policy of India, and held that shareholders' agreement was not void or opposed to the FEMA or any other Indian law. One important aspect which the court held was that contracts entered into with free consent, especially with foreign entities, ought to be honored and enforced, because non-compliance and breach will materially affect India's reputation in global economy. It is an articulated reasoning which one will find in that judgment of Delhi High Court. This has been kind of a watershed decision which cemented the way in which courts in India have commenced considering public policy objections, even in the context of claimed breaches of key regulatory statutory provision, such as FEMA and other regulations framed hereunder. Similar case which came up on was a case which is called Shaktinath versus Alpha Tiger. In that particular case, the objection which was raised was that the exercise of the put option under the shareholders agreement was in contravention of the RBI circular and FEMA regulations, and therefore the relief which was sought in the arbitration proceeding was violative of fundamental policy of India. This objection was rejected by the Delhi High Court for the reason that the claimant in the arbitration proceeding have confined their relief exclusively to claiming damages on the breach of contract. The High Court therefore rejected the attempt of the petitioners to invalidate the contract and the resultant award as being violative of public policy of India on account of purported breach of foreign exchange and investment law. In support of this reasoning, High Court very interestingly noted that the parties who enter into contract with open eyes accept the burdens as well as benefit of the contract, and therefore they are bound by what they agreed to. The High Court also again reinforced its stand of minimal interference with arbitral awards, even when challenged on grounds of public policy violations, by adopting a narrow construction of the phrase fundamental public policy of India, as has been contained in Section 34 of 1996 Act, under which this award was challenged. I would request you and encourage you to put your questions on the questions window, which is there, and we will try and answer as many as possible after we finish the presentation and take on questions and answers. Thank you. Another case which is quite important is Cruise City Mauritius Holdings versus Unitech Limited. In here also the enforcement of the award was resisted on the ground that award violated the fundamental policy of Indian law. Their case was that provisions of a law in India barred any foreign direct investment to get an assured return, and what award was giving to Unitech an assured return. And it was therefore argued that put option contained in the shareholders agreement was violative of the law, as it guaranteed a fixed return and thus violated the exchange regulation laws of the country. This contention was also rejected by the court, and parties were forced to comply with their part of the contract. So essentially, what we can see now is that any kind of very creative defenses which are being raised as to why a party should be excused from performing an obligation which has solemnly entered by it at the time of negotiating the contract and entering into the agreement, by bringing in all these kind of clauses of it being violative of fundamental policy of Indian law or against the public policy or the terms of the contract being coercive, etc. All that is something which is being now taken out by the court, and the inference which we can draw from these judgments and many judgments which have come in recent past is that the approach of the courts essentially is to obligate the parties to honor their promises under the contract, rather than to get out of those promises by raising some kind of a technical pleas of violation of some kind of a law, etc. In this context, I think it would also be very important for us to understand what is the approach of the court when people had come to the court and said that a proceeding which is going on in a foreign court or a arbitration which is being conducted should be stalled or stopped for certain reasons which they articulate before the court. One of the recent case and a very important case is the case of Union of India versus Vodafone. This was a case where in Union of India sought actually a stay or an anti-arbitration injunction against Vodafone UK from pursuing its claim under India-United Kingdom bilateral investment treaty. There was a bilateral investment treaty which has been initiated by Vodafone against India. And Union of India approached Delhi High Court and said that that bilateral investment treaty should not go for the reasons which were stated in that injunction suit One of the reasons being a similar kind of a BIT is already pending, and therefore two BITs should not go ahead, etc. India actually had argued that Vodafone, which was a Netherlands entity, had earlier initiated an arbitration under the Netherlands India BIT, and that Vodafone UK should now be barred from invoking arbitration under the India UK BIT of the same cause of action. Vodafone, on the other hand, contended that Indian courts do not have jurisdiction to decide claims which are arising out of BITs under the 1996 Act. While Delhi High Court held that it does have jurisdiction even on bilateral investment treaties, and Indian courts can interfere in those processes also, but they refused to grant an anti-arbitration injunction and observed that such a power must be exercised by the court with abundant caution, and that such injunctions ought to be only granted if the arbitration proceedings are vexatious or an abuse of the process. Therefore, while holding that they have jurisdiction, by this judgment, they considerably narrowed down the grounds for granting anti-arbitration injunctions. So again, I think the court reinforced its non-interventionist stance. While we are speaking of anti-arbitration injunctions, Modi Entertainment Network versus WSG Cricket Private Limited is one of the leading cases on the subject, which reinforces that Indian courts are not really keen in interfering with an adjudication process which has already been started, either in foreign shores or before the Indian court. In this particular case, on an anti-injunction suit, the Supreme Court of India has held that the court should exercise the power of granting anti-suit injunctions very sparingly in order to avoid any potential interference with the jurisdiction of another civil court. Because in here, the action between the same parties were pending before an English court. And they said that this would be a recognition of the principle of comity of courts. The Supreme Court also clarified that such injunctions could be granted by courts where the proceedings are vexatious or oppressive, and in case where the injustice is being perpetuated. So again, a very high bar for stifling a process which is going in foreign shores or before an arbitral forum has been set up by the Indian court, again emphasizes its non-interventionist approach. While on the subject, we might also point it out that the courts have said that in case the parties have agreed to an arbitration, then in that particular case, they would go to the chosen dispute resolution mechanism, which is arbitration before the forum which they have decided, and they can't come to Indian courts and file a civil suit on the same action, which would be a subject matter of that arbitration. And the Hell Energy case, as we generally call it, is a case which is very recent case of 23rd of September 2019, wherein a plea of forum non-convenience was set up by the party, saying that the seat of the arbitration which has been decided is something which is not acceptable to them because that is a foreign country, and that would be a foreign non-convenience to them. But the court in this particular case held that if the parties have agreed to a forum, then in that particular case they can't rush to the court and seek intervention of the court, and they would be required to go to the specific seat of arbitration that has been decided by the parties, because they have entered into that contract which is by their free consent. So I will again kind of request you, in case you have some questions, then please post those questions, because we are coming towards the end of our presentation and we will be very happy to take those questions. So from from, I think, the key takeaways from the legislative changes as well as the recent approach of the courts would be that Indian courts have actually refused to allow dishonor of a contractual obligation in terms of an enforcement of agreed dispute resolution provision. If they have agreed to an arbitration clause, the courts have sent them to arbitration, and they have refused to entertain the argument that allowing damages to be awarded for breach of a contractual obligation would be a violation of the fundamental policy of Indian law. India is certainly gearing up towards ensuring certainty in contractual enforcement. I think that is evident from ranking of the India jumping in ease of doing enforcement, also on the aspect of enforcement of contractual disputes. But it also advises us is very clear that there is a legal minefield and there is a possibility of various kind of defenses which can be very innovative and very creative defenses which can be set up when actually it will come to enforcement of the contract. Therefore, incorporating an effective dispute resolution clause in the contract, including the method of the dispute resolution, jurisdiction, choice of law, seat, etc., so that time is not lost on ambiguity and a chance is not given to other sides to play on that kind of an ambiguity. And I think a early advice at the stage of entering into the contract itself or the transaction interest itself to check the compliance with Indian law and also the legal regime as has been interpreted by Indian law and detection of problem areas for avoidance of mistakes would be something which would be very much advisable.
Excellent. Thank you very much, Sanjeev. And on the money, we have, ladies and gentlemen, roughly 18 minutes for questions. We've received quite a few questions already. Allow us a minute. We will go on mute and cycle through at least the first couple of questions that we should pick up. Okay, so let's start with this, and I'm rephrasing the question a little bit, and maybe Sanjeev, you would like to take this.
Sure.
The question is that one of our initial slides spoke of liquidated damages. How effective is that as a remedy, and what are the touch points that one should be mindful of?
So, I think it's not really very simple to enforce liquidated clauses in India. There are some inherent limitations which have come up because of the judgments of the court. So, I think liquidated damages before being enforced are required to be held to be reasonable. There should be a genuine pre-estimate of the breach which is anticipated or could be caused in case the contract doesn't function the way it has to function. And the courts have also held that in case you don't just get liquidated damages for asking. Liquidated damages, they have said, would be the ceiling which you will get. But up to that ceiling also, you need to prove liquidated damages. The only exception is that when it is difficult or impossible to prove losses in a particular case, then liquidated damages are used as a rough and ready estimate. So I think the few critical things is that while you are looking at the liquidated damages clause, you should ensure that this is a reasonable and a genuine pre-estimate of the damages which has been caused. You must be mindful of the fact that that is going to then get treated as a ceiling for that breach, and to that ceiling also you will not get it for asking. You might have to prove, unless you are able to prove that the damages are impossible to be computed. These, I think, are something which one should be very mindful when one is looking at liquidated damages in an Indian scenario.
Interesting. We have quite a few questions around what is the preferred dispute resolution forum. So just to sort of club all of those together, what is, to your mind and experience, and what would you see as the preferred seat of arbitration being used in cross-border scenarios? And also, there's a specific question around whether a multiple institutional investors would SIAC, which is the Singapore center, still remain as popular, or is there some preference for the Indian jurisdiction?
So I think when it comes to foreign disputes, two forums which we find, in fact, there are three forums which we find which are there and used quite a lot. We have seen complicated, high-value transactions with a European angle going to London. It's either ICC London or most preferably LCIA London. And the other thing which we have seen which are disputes which has got more Asian focus, we have seen SIAC. According to me, both are very robust institutions. All the three are quite robust institutions, whether it is ICC, whether it is LCIA, whether it is SIAC. Quite robust institutions which are very credible. We have experience of them testing in the courts, and we have seen those awards getting enforced. So there is a kind of a familiarity of the awards which have been passed by these institutions with Indian judges also, and there is a certain kind of a credibility which is already attached to it. So depending upon the preference of the parties and geographical location of, in case it goes to a dispute where witnesses would be based, and what would be more convenient for them to you. Any three of these we see getting incorporated as Indian dispute resolution clauses.
Right. And increasingly what we're also seeing as a trend is a lot of times where, say, Indian counterparties have a concern in arbitrating before a foreign fora, they may choose to press for arbitration in India. So therefore, the actual dollar expenditure of and the convenience of it is preserved, but it may be arbitration, say, with a seat in Singapore, or which may be administered by rules of the Singapore Center, essentially so that you try and marry the benefits of pleasing the Indian counterparty, at the same time preserve the ability to use an institution rather than pure ad hoc arbitration.
That's correct.
The next one really is around and again, bunch of different questions put together. So what is the kind of leverage, and what are the kind of security options that need to be created in a dispute scenario, and both in a pre-contractual and in a dispute stage? So I'll maybe take the pre-contractual piece and hand over to you, Sanjeev. But probably on the pre-contractual stage, it's important to understand that we've spoken about how dispute resolution in India is on the up, and gradually it is being made more efficacious and more efficient, but it does take its own time, and there are challenges in implementing, for instance, indemnity claims and so on. What we are seeing is that a lot of investors, particularly cross-border investors, do favor either an escrow or some sort of a holdback, and traditionally it wasn't the easiest thing to do because of exchange control restrictions, but over the last 3 or 4 years, there have been some changes to exchange control restrictions that allow you to, for instance, have an 18-month escrow, or you could build in certain additional creative solutions around it. So that's something that you really need to start thinking about. If there is a risk which you believe is imminent, then maybe you need to start factoring an escrow around it, simply because if at all there's an indemnity claim, there'll be an incentive for the counterparty to settle. That's one option. The second is, if for instance you're not doing a complete transaction, let's say if you're leaving a residual stake to be picked up subsequently, some sort of a set of mechanism in relation to indemnity claims and subsequent purchases is also quite common, simply because it allows you again the ability to recover whatever losses you have. The third thing that you could do, and again becoming increasingly popular, for instance, say where you have a private equity seller exiting, is to pick up insurance on reps and warranties. While it won't cover you for known issues, at least the fear of the unknown can be put to rest based on buying a robust insurance policy from well-known insurers. And in terms of at the litigation stage, how would you sort of preserve value? Any thoughts?
So I think this is happening quite a lot because you don't want to go through a arbitration process or a litigation process and be handed over with either an award or a decree, which then you find out is a paper decree or a paper award, because while you were fighting that litigation or arbitration, all the underlying assets have been siphoned off, and there is nothing left out against which you would be able to enforce that. So there is obviously protections which people seek. You have Section 9 of Arbitration and Conciliation Act. You have got emergency arbitrator provisions in LCIA, ICC, SEAC, under which before the arbitration even starts, you can go, you can seek freezing of the account, you can seek orders restraining third-party right, encumbrances, etc., to be created on the assets of the parties. On the Code of Civil Procedure also, in case of suits, etc., you have got provisions like Order 38, Rule 5, which is attachment before judgment. And we see that these are tools which are getting very, very effectively deployed. And we see that the courts see to this particular thing, and in many cases, they do preserve the assets so that award doesn't come as a paper award. And obviously, the order which has come out from the Supreme Court today in Daiichi Sankyo is for a contempt, because an order of this nature, which was granted towards the preservation of assets, in view of the Supreme Court, got violated, and obviously. So there are various ways and means depending upon a fact situation and the asset base of the opposite party, that you can approach the courts, and while the process is going on, or even before the process is initiated, you can secure it yourself, so that ultimately, in case you succeed in the process, then you can have enforcement against those assets which remain preserved.
The next question seems to be in the context of diligence, and the question is, how would you view whether diligence is a disclosure to warranties or not? So there again, there are two parts. One is what is market practice, and one is what is law. So as per market practice, if you ask a deal lawyer in the country, there are more instances where diligence is not a disclosure than there are instances of where diligence is a disclosure. This is again a principle which is very well accepted in Western jurisdictions, but for whatever it is worth, the Indian market practice has evolved on its own pace. Let's assume you are in one of those instances where diligence is not treated as a disclosure. Even in that scenario, you can't rule out a situation that something that may have been provided in diligence may defeat a warranty claim subsequently. Therefore, what we very strongly recommend is that if you're spotting any liability issues in diligence, it's very important to bring those forth as indemnity items and negotiate them upfront, as opposed to, for instance, relying on silence in disclosure and making a warranty claim should a loss ever arise. If we were to follow UK law as such, yes, there would be comfort, but then Indian law, I believe, would evolve realistically on its own. The next question, again linked to indemnities, is to what extent would Indian courts allow parties freedom to determine the nature of indemnities? So here, I guess there are two instances that we can pick up. Let me just very quickly talk about one, which is about diminution in value, and this is probably of most interest to financial sponsors, because not necessarily would each and every loss that is of interest to them arise out of an actual out-of-pocket loss to their target company. There are also questions that we are seeing in terms of fraud by promoters in terms of financial statements or otherwise. Now, those sorts of instances would lead to a loss of value in the hands of the investor, but not necessarily lead to any out-of-pocket loss as far as the company is concerned. So in that instance, it's critical to have your indemnification provisions appropriately addressing diminution in value. And I believe there's been a recent case law as well, Sanjeev.
That's right. That's right. So there have been Delhi High Court and Bombay High Court judgments in the Anik Bhaskar case and also in Welspun Infra case. So I think generally, if you have got a clause of indemnity which is very vague, it is just not very clear, etc., then generally the law is that unless the person who is indemnified has incurred the liability, and that liability is absolute, uh, 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 till that particular point of time, he is not entitled to call upon the indemnifier to save him from that loss and pay it. But if your indemnity clause is very clear and very specific, and let's say you have an indemnity clause which happens on happening of an event. Let's say there's a trigger event which has been identified in the indemnity clause, and that trigger event might ultimately not result in a loss. Let's say your trigger event is that in case there is a show cause notice which comes from the tax department, whether that liability is given by you or whether you have to contest that tax demand, etc. And the clause says the moment the notice is received by you, you have to pay the indemnity. The courts have held that if that is the intent of the parties in that particular case, that is something which is required to be honored. And those kind of indemnities, which are very clear and unambiguous, are honored by Indian courts in that particular extent.
And increasingly, things of those nature would not be permissible under traditional damages remedy, because damages is a very compensatory sort of a remedy. You first have to demonstrate there was a breach, the breach led to a loss, you actually suffered the loss, and only then can you go back and seek what is compensatory in nature. Whereas an indemnity provision is really a creature of contract, and you can choose to define it with as great a level of flexibility as you can. Of course, with a certain semblance of reasonableness. You can't ask for the sun and the moon, but at the same time, please feel free to cover off all the edges as you must.
Precisely. And I think indemnity provisions are very, very critical, and the indemnity provisions of the like are very, very critical for getting the interim relief which we were talking about. So if you have got an indemnity which says on happening on an event you are entitled to an X amount of money, then on the basis of that particular provision, a court would be very willing to grant you an interim protection of that particular amount. Obviously, for indemnity also, you'll have to go through the legal process. But having these kind of very, very structured, clear clauses would be very useful for you also. It would be easier for you to get the indemnity clauses enforced, but it would be very useful for you also to get interim protection while these indemnity clauses are being tested.
Okay, I see we have 3 minutes left. Maybe we can pick up one more question. So we've received a question around exchange controls, because we spoke of Docomo, we spoke of Cruise City, we spoke of exchange controls and how they function. And what we've been asked is that in a transaction, what should a purchaser slash investor look to ensure they have coverage for, so that their remedy is not shortchanged by restrictions under exchange control? And that's an interesting question. Practically speaking, few things that you have to bear in mind if you're a cross-border investor or a cross-border purchaser. Your ability to take any kind of damages or indemnities out of India may require a Reserve Bank of India approval. And therefore, you need to have clarity as to who's really responsible for obtaining that approval. It shouldn't so happen that that's a responsibility that sits on you. The second part is that if you're looking to purchase shares of an Indian company, and in relation to that share purchase you're seeking to take any monies out, there is an unsaid sort of restriction that you must leave at least fair market value with the seller. And therefore, when you're doing your transaction, it's very critical to assess whether your transaction value leaves any room between itself and the fair market value determined for it. Anything to add there?
So I would say that yes, and that is one of the key takeaways also which we stated at the end of the presentation essentially was that if you have a clause which is in the teeth of Indian law or FEMA regulations, then obviously it would be difficult to get that enforced, because you really can't have enforcement of some provision which is clearly in violation of a law in India. But in case you have got representation, warranties, obligations on somebody that he would be doing what is required under the exchange control law, and he fails to do that for any reason whatsoever, then that case doesn't become a case of violation of FEMA regulation, but it becomes a case of breach by that particular party of honoring an obligation which he has undertaken on himself. And for that breach, you can be compensated. So maybe ultimately you will end up getting the same kind of a result. But when you look at from the point of view of a legal enforcement, it makes quite a lot of difference, because then either the arbitral tribunal or the court is not really concerned with as to whether the Indian law has been violated. They are more concerned with whether a violation of an obligation which resulted in breach for which the other side is to be compensated happened or not.
So, ladies and gentlemen, thank you. With that, we come to the end of the hour. We still have questions streaming in. What we'll probably need to do is, our contact details are there on the last slide, and should there be any questions, please feel free to reach out to us. But thank you for having been a wonderful audience, and it's been a pleasure for both of us to have addressed you, and we look forward to keeping in touch.
Thank you so much.
Have a wonderful day.